Welcome to today's presentation of Section 504, A Parent's Guide. My name is Deb Belanger, and I'm the Training and Technical Assistance Manager here at Rhode Island Parent Information Network. RIPIN is the state's designated Parent Training and Information Center for Rhode Island, one of many parent centers throughout the country. We were established in 1991 and have been providing information, resources, training, and support to families and individuals for over 20 years, including families of children with disabilities. Section 504, A Parent's Guide, is one of our many workshops and trainings RIPIN provides, with today's presentation focusing on a basic overview of Section 504. In addition to the PowerPoint slides, we have also included a number of other resources which may be helpful. At the end of today's presentation, we ask that you take a minute and complete a short survey in order to provide us with feedback. We utilize your input in order to improve the information we share with families. So let's get started. Here's what we'll be covering. What is Section 504? We'll talk a little bit about the history of Section 504 and about the role of the Office of Civil Rights before we move into the steps of identification, evaluation, process, and plan. We'll end with the procedural safeguards, which are the rights the parent and student have, and end with what you can do to resolve any disputes that might arise. So, what is Section 504? Section 504 is a federal law designed to protect the rights of individuals with disabilities in programs and activities that receive federal financial assistance from the U.S. Department of Education. The most important thing to remember is that Section 504 is a civil rights law which prohibits discrimination against students with disabilities in programs receiving that federal funding, like schools, colleges, and universities. The general education system is responsible for implementing the supports and accommodations needed to provide a student with their free and appropriate public education, which moving forward we will refer to as FAPE. Other language you'll hear throughout the presentation, and we want you to become comfortable with using are providing access to FAPE, removing barriers to FAPE, and preventing discrimination. This may be new language that you're hearing for the first time. And ultimately, this is what Section 504 does. In creating this workshop, it was interesting to learn that Section 504 of the Rehabilitation Act of 1973 preceded the enactment of the Americans with Disabilities Act by nearly 20 years. As you know, the Americans with Disabilities Act was the first comprehensive civil rights law for people with disabilities. Now, this law applies to all state and local governments, including public schools, colleges, and universities. But in 1999, some of the provisions of the ADA were narrowed by the Supreme Court rulings, which limited the scope of opportunities and protections that were originally intended. The good news is that in 2008, Congress responded to this constriction by passing the Americans with Disabilities Act Amendments Act, ADAAA, which included a conforming amendment to Section 504. These new regulations were important for our returning wounded soldiers who certainly deserve the right to re-enter a workforce free of discrimination. Before moving forward, let's talk about the Office of Civil Rights. OCR is the federal agency under the U.S. Department of Education that provides oversight to the implementation of this law. They have to ensure equal access to education and enforcement responsibilities under Section 504 of the Rehabilitation Act of 1973 and the Americans with Disabilities Act of 1990. Every school district and nearly every college and university in the U.S. is subject to one or both of these laws. OCR's role is to process and investigate complaints. They will work with schools to resolve issues at the earliest point and provide compliance reviews to schools, colleges, and universities. The compliance reviews are provided when there's been a history of complaints with a particular school system. Additionally, OCR will provide technical assistance in the form of presentations to districts in order to provide information about compliance. They also respond to inquiries via phone calls and emails, letter correspondence. When it comes to impartial hearings, though, for Section 504, the Rhode Island Department of Education handles those issues. So, did you know that effective January 2009, when the ADAAA was implemented, eligibility for protection under Section 504 of the Rehabilitation Act became broader? You'll be especially interested in these developments if your child was evaluated under IDEA for an IEP, but was found ineligible. If your child was previously evaluated for Section 504, but was found ineligible. If your child is currently receiving informal accommodations in school, or if your child has a Section 504 plan in place. For many students with learning disabilities and/or ADHD, this is great news. We'll discuss this further as we go throughout the presentation. I mentioned FAPE at the beginning of the presentation. Let's talk more about free, appropriate public education. Appropriate education programs for students with disabilities must be designed to meet the unique needs of students with disabilities to the same extent that the needs of non-disabled students are met. Schools are required to fund and implement Section 504 in providing FAPE to each qualified student with a disability who is in the school district's jurisdiction, regardless of the nature of severity of the disability. Section 504 creates equal opportunity, leveling the playing field for students with disabilities. For more information on FAPE, refer to the FAPE resource from the Office of Civil Rights located as a handout below. Here's where we begin. Identifying a student with a disability under Section 504 begins with the evaluation process. It requires school districts to individually evaluate a student before classifying the student as having a disability. Collecting accurate documentation is one of the most important aspects in determining disability. It's important that schools are making determinations that are individual and not generalizations. In the process of identifying a student with a disability, schools might look for something called patterns of change. For example, a pattern of change could be when a student is absent due to hospitalizations or sent home repeatedly due to behavior or any type of ongoing failure. Because schools must evaluate all students suspected of disability, requiring Section 504 protection, all factors relating to the student's learning process must be considered and, most importantly, documented. These include tests and other evaluation materials tailored to evaluate education needs. Educational needs include both academic and functional needs. The same process is used to evaluate the needs of students needing special education under IDEA, and it's important that the data used is objective. Before we can move forward with evaluation, it's important to understand the definition of disability. The ADAAA did not change the basic definition of disability, but rather the manner in which the definition is interpreted. Disability is defined as having a physical or mental impairment, which substantially limits one or more major life activities, having documentation of the impairment, or being regarded as having impairment. Now, you can have impairment, but unless it fits the definition, it does not automatically become disability. For example, having diabetes doesn't become disability unless it substantially limits one or more major life activities. The same goes with any other impairment. What's most important is having a record of such impairment. The evaluative documentation is important as the first step in the process. Let's take a look at a list of some major life activities. But this is not an exhaustive list. And remember, impairment in and of itself is not disability. The impairment must substantially limit one or more of these activities in order to be considered a disability under Section 504. Limitation in one major life activity does not need to impact other major life activities in order to trigger ADAAA protection. Some students with disabilities struggle in just one academic area, such as reading or writing, but excel in other skills or subjects and shine in extracurricular activities. Such students might now qualify for ADAAA protection, whereas before 2009, they would have been found ineligible because they struggled in only one major life activity. The definition of major life activities was expanded to include reading, concentrating, and thinking. Also, the definition of major bodily functions has been expanded to include neurological and brain functions. This change makes it easier for individuals with learning disabilities and/or ADHD to qualify for protections under the ADAAA. Understanding what constitutes physical or mental impairment is defined as having a physiological disorder or condition, cosmetic disfigurement, or anatomical loss that affects one or more of these listed major bodily functions. Again, this is not an exhaustive list of specific diseases and conditions that constitute impairment because of the difficulty ensuring the comprehensiveness of such a list. Mental or psychological disorder examples include intellectual disability or mental retardation, organic brain syndrome, emotional and mental illness, and specific learning disabilities. In determining whether a student has a physical or mental impairment that substantially limits that student in a major life activity, schools must not consider the ameliorating effects of any mitigating measures that the student is using. In simple terms, schools cannot consider accommodations or supports that the student is already using in order to determine disability. This is an important change from prior law. Now, substantial limitation does not mean severe restriction or inability in performing major life activities. It's important to note that OCR, the Office of Civil Rights, does not endorse a single formula or scale that measures substantial limitation. It's important to know that although a district's 504 administrator can make the decision whether a student does or does not qualify as a child with a disability with substantial limitation, parents should request the district's 504 procedural safeguards when there's disagreement. We will discuss dispute resolution closer to the end of this presentation. Here are some examples of mitigating measures. Under the Americans with Disabilities Amendment Act, a person cannot be denied protection, and therefore protected from discrimination, as a person with a disability simply because he or she uses a mitigating measure, such as taking medication for ADHD, or being allowed extra time when taking tests to accommodate for a learning disability. The only exception to this is corrective lenses that fully correct a vision problem. So, for a student with a respiratory impairment, schools can only determine disability without regard to the use of oxygen therapy. For a student with a physical impairment, schools can only determine disability without regard to the use of prosthetic device. For a student with a traumatic brain injury, schools can only determine disability without regard to the use of assistive technology, such as an augmentative communication device or a computer adapted for the student's physical needs. And lastly, for a student with mental health issues taking medication, if the side effects of the medication substantially limit the person in a major life activity, such as concentration, he or she could be covered by the ADAAA and entitled to an accommodation, even though the symptoms of the disability are addressed by the medication. In addition to mental or physical impairments discussed earlier, episodic impairment is also affected by Section 504. Chronic impairments that are episodic or in remission are considered disability, if it substantially limits a major life activity when the impairment is active. Here are some examples. Seasonal asthma. We know of a student who was provided temporary transportation by a special education bus in order to avoid cold air during certain months of the year because the cold air triggered extreme asthma attacks, which sent her to the hospital. For bipolar disorder, students whose mood swings cycle throughout the year and affect their education may need accommodations at certain times of the year. Examples, allowing for flexible scheduling, more frequent breaks, even additional time to complete work or learn new concepts, time for counseling, dividing large assignments into smaller tasks and goals, reducing distractions, providing positive praise and reinforcement. These examples may be needed at certain times of the year for a student with this type of disorder. Similarly, if an impairment such as cancer is in remission, but there is a possibility that it could return in a substantially limiting form, then under the ADAAA, this would meet the definition of disability. Celiac and Crohn's would also be another example that could certainly affect that student's education. So at this point in our presentation, let's assume the student has been evaluated and was determined to have a disability because his or her impairment limits a major life activity or bodily function and was therefore found eligible for 504 protection. Now let's discuss what does the student need to assure that he or she receives their free, appropriate public education. The next step requires that decisions are made by a group of individuals with knowledge of the student's needs. What barriers need to be removed in order for the student to have access to FAPE? Accommodations are provided in order to level that playing field and eliminate discrimination. It's important to note that accommodations are not intended to reduce learning expectations. Without accommodations, students with disabilities may not be able to access grade-level instruction and participate fully on assessments. This becomes a two-part process for schools, with districts determining disability and determining what accommodations are needed to eliminate discrimination. Although there is nothing stated in the law that requires an accommodation plan be in writing, it does require documentation of disability and how barriers will be removed to access FAPE. Writing some sort of a plan is considered best practice. We suggest that parents who do not receive something in writing follow up their meetings with their own documentation and provide the district with a summary of what they walked away with from the 504 discussion. Here's a non-exhaustive list of possible accommodations. For example, a student in a wheelchair might not need any other accommodations other than an emergency evacuation plan for when they are on the upper floors of a school during an emergency when elevators are not available. A health plan may be needed for the student who requires medicine throughout the day or access to certain medical devices in an emergency, like an EpiPen. As discussed earlier, the use of a special education bus to pick up and drop off a student at the door of her home and school during the colder months due to her asthma. Providing a student with support and or personnel needed during extracurricular activities and field trips. These activities are all part of that student's free and appropriate public education. The goal of the Americans with Disabilities Act is not to equal test scores, but equal opportunity. The question is to always consider, without the accommodation, will the student have access to their free and appropriate public education? Now that we've determined what the needs are of the student and what accommodations are required to remove any barriers to their education, a question that sometimes comes up is, where will the student be educated? There is no one location setting for students with disabilities, and location is determined on a case-by-case basis by a group of people knowledgeable about the child. The qualified student is to be educated with students without disabilities to the maximum extent appropriate to the needs of the student. Least restrictive environment still applies. Students with disabilities should be placed in the regular education environment unless their education cannot be achieved there satisfactorily with the use of supplemental aids, accommodations, and services. Accommodations are applicable throughout non-academic and extracurricular activities, with participation to the maximum extent appropriate. For example, drama club, after-school sports, field trips, anywhere other students are participating, the accommodations are still applicable. When it comes to implementing the 504 accommodation plan, all school personnel involved with the student need to be aware of the plan. Following the plan is not optional. Periodic reevaluation is important to assure that data reflecting the needs of the student is up to date. Best practice is every 3 years, but it's not required. It is important to remember that the law does not require a specific document or plan, yet it does require the district to have documentation. How does a 504 plan differ from an individual education plan or an IEP? A 504 plan attempts to remove barriers and level the playing field for students with disabilities in order for them to have the same opportunities as everyone else. An IEP does more than level a playing field and provides significant remediation and assistance, with the student more likely to work at their own level, at their own pace, even in an inclusive classroom. Only certain classifications of disability are eligible for an IEP, and students who do not meet those classifications but still require some assistance to be able to participate fully in school would be candidates for a 504 plan. In addition, as stated previously, a 504 requires a plan, but an IEP requires a specific document. If plan is not in writing, a parent should write a letter after a meeting, incorporating the discussion and key points in writing. By documenting that the child has a disability which substantially limits a major life activity, parents are keeping a record by providing documentation. This also helps when transitioning to a new school or a new setting, changes in teachers, and other life events. One of the other handouts provided today is from the National Center for Learning Disabilities, a parent advocacy brief. On pages 9 and 10, there's a side-by-side IDEA 504, a comparison chart that might be helpful. Procedural safeguards are procedures explained to a parent or guardian in order for them to be informed throughout the process. A district is required to provide a system of procedural safeguards which includes parental rights and notice of a district's actions. If a school district is denying evaluations and accommodations under Section 504, districts are supposed to provide parents with their procedural safeguards. This includes the right to an impartial due process hearing, which in our state is handled by the Rhode Island Department of Education. Parents have the right to access and review records. Although IDEA requires that districts provide copies, 504 does not always necessitate copies. Lastly, hearing officers can review school districts' decisions about evaluations and accommodations to see whether the district made the appropriate call based on the student's needs. The Office of Civil Rights, through the complaint process or otherwise, cannot make these types of determinations. Districts should have at least one 504 coordinator, where others may have a coordinator at each school building. Parents can request grievance procedures, which may be included in the school district's handbooks, websites, or other forms of documentation. Grievance procedures and the coordinator requirement are also included in post-secondary education. Prior to filing a complaint with the Office of Civil Rights against any institution, a potential complainant should find out about the school's grievance process and use that process to have the complaint resolved. We encourage parents to contact RIPIN's Resource Center for support in navigating the 504 process. In addition, parents should contact the Rhode Island Department of Education's legal department for assistance in resolving the dispute at the lowest level before contacting OCR. However, if necessary, parents can file a complaint at any point as early as they want with the Office of Civil Rights. This slide shows the contact information when filing a complaint with the Office of Civil Rights. Here are the phone numbers and contact information. Use the Office of Civil Rights as an additional resource to proactively move forward. These are some additional resources that might be helpful. We use these in creating this training. To find out more information on the Office of Civil Rights in Section 504, visit www.ed.gov/OCR. Thank you for joining today's presentation of Section 504, A Parent's Guide. For more information about Rhode Island Parent Information, our resources, and the workshops we offer, please contact RIPIN's Resource Center at area code 401-270-0101 or visit our website at www.ripin.org. We ask that you help us continue offering this type of information to families and individuals by completing the below survey. Thank you for taking the time, and we look forward to hearing from you.